Good morning, WTOB listeners. This is Dylan Greenwood along with Harold Eustache of Greenwood Law on For the Record with Greenwood Law, coming to you this morning here on WTOB. And today we're going to be talking about a hot button topic here in North Carolina and really around the country, something that's fallen into scrutiny over the past year plus, and that is the issue of police body cam footage and the public's right to be able to see that. And it's not just the public's right, but it's the right of the families of people who are involved, the potential defendant in a case to be able to see that kind of stuff. And it's a very serious topic. Of course, it's serious right now because of what is going on in Punkwatuck County with Andrew Brown. And there's been a big call for that footage to be released. And there have been a lot of things that have happened, a lot of protests, a lot of demonstrations. A lot of people don't understand why it can't just be released.
Right.
And North Carolina doesn't make that so simple, does it, Harold?
No, it doesn't. Right now in that Andrew Brown case, what's happened is the family has been able to view privately, in confidence, about 19 minutes of footage, which has been redacted. That is not apparently all of the footage. There were several officers on the scene, so there's actually hours of footage, or over an hour of footage. So the family's only seen snippets of that. And so a lot of people are wondering, well, why is this being hidden? What it looks like. Why is the family seeing this in confidence? How come they're only seeing part of it? And so we're going to talk through some of that. And so, first thing is when we look at this case of Andrew Brown in Elizabeth City, and then you kind of juxtapose that with what happened in Columbus, Ohio recently, and how that video was able to be released very, very quickly. And part of the reason is because Ohio just has a different law around those types of videos. Those videos in Ohio are a public record, and law enforcement agencies in Ohio are able to unilaterally release that video, those types of videos, without the consent of a judge. And that just isn't the case in North Carolina because of a 2016 bill that we had that really codified all the law around body cameras.
Right, and there have been two other incidents have occurred in Ohio and Minnesota in which officials did release body cam pretty quickly. One of them was in Minnesota back on April the 11th with Dante Wright, and the officer in that case has since been charged with second-degree manslaughter. And that video was released very quickly, and it was decided by officials in the case or in that area. They made a unilateral decision to release that footage. They were not required by law to release the footage in any way, but they had the ability to make the decision, and they did so after some intense demonstrations. Again, it also happened around the time of the George Floyd trial. So that was obviously an atomic bomb that was waiting to go off.
Right.
And that release seemed to quell at least some of the emotions.
I think it did, and I think that's partly why these videos in Ohio and Minnesota were released. Because, the Minnesota video, I think, was during the George Floyd trial, and at least it seemed to me that video was released to kind of so that law enforcement could show what happened and maybe even distance themselves a little bit from that incident and quell some of the protests. And then in Ohio, I think it might have been released for a different reason. I think because of what it sounded like. This happened, Kyla Bryant. This happened right after the verdict in George Floyd. Of course, the country's all up in arms about that in different ways. And so when people heard that this young girl had been killed very quickly, people were I think inquisitive about what happened. And so that police department in Columbus released that video to show, because they thought it was justified. And I think that actually also quelched some of the protests, because when people really watched that video and analyzed it, I think a lot of people thought, okay, well, there was a knife there, this other girl could have been stabbed, and so it helped to lower the pressure. And so it makes you think, well, why isn't North Carolina doing the same thing?
Well, in Minnesota, or especially in Minneapolis, where this, stuff with George Floyd occurred, I think there was a lack of transparency to begin with around George Floyd.
Mm-hmm.
You can even look at the posts that were sent out on social media right after it happened, and you juxtapose that with the evidence that came out at trial.
Oh, yeah.
The
statement
oh my gosh,
from the police department was just awful.
It sends chills down your spine,
right.
Of the portrayal of that versus the evidence that came out. And so it represented a big shift in transparency. And a lot of civil liberties organizations of the sort call for this type of government transparency especially in cases like this, so that we can know what occurred. Because when it gets down to it, Harold, the video doesn't lie. The video is recording. It's an unbiased recorder of what is occurring. And for that video to be admitted in a court of law, you have to be able to establish the chain of the custody of the video itself. You have to be able to establish that no one tampered with the video in any way, so that you do know that you can rely on it. And then once it's admitted, then it's up to everybody watching it to go, well, either this did or did not happen. And yes, you do only get one focal point perspective, but it's still better than not being there at all. Because, Harold, I know, and you've seen this, I've seen this, we have seen testimony that is different than a police report. We have seen video that is different than a police report. Some of that can be attributed to the fact that some people aren't good at conveying themselves through writing.
Right.
And so things aren't clear. That's what you hope. It doesn't always occur that way, and it seems apparent otherwise. And you're sitting there with somebody beside of you, a client, going, if we didn't have this video to set this straight, what would get testified to? What would the report, show, that would be relied upon, and what would happen to this individual? Whereas, that video, like I said, it's an unbiased observer.
No, it really is. And that's why in 2016, House Bill 972 established what a body cam recording was or wasn't. And essentially the main thing to remember is that it's not public record in North Carolina. It's sort of a quasi-public record, but there are certain procedures around disclosure of these types of videos. So in order to get one of these videos, even whether it's in order to release one of these videos, even if it's a law enforcement agency, even if it's the head of the law enforcement agency, they can't just release it. They have to petition the court and go before a judge, and a judge has to sign off on the release of a video. And that is true and the petition can come from law enforcement, but it can also come from either a family member, a person in the video, a defendant, or an agent of that defendant, i.e. a lawyer or someone else. And in order to release it, the courts and the judge looks at various factors. There are 8 really different factors that a judge will look at, and I'll just name them really quickly. But the first is that it satisfies a compelling public interest, that the recording contains information that is otherwise confidential or exempt from disclosure, that the person requesting release is seeking to obtain evidence to determine the legal issues, which is what a lot of lawyers are looking at. Release would reveal information regarding a person that is of highly sensitive personal nature. Release may harm the reputation or jeopardize the safety of a person. Release would create a serious threat to the fair, impartial, or orderly administration of justice. Confidentiality is necessary to protect either an active or inactive internal criminal investigation. Or 8, there is good cause shown to release all portions of the recording. 8 is sort of a catch-all. But But essentially, what these 8 factors are is a balancing test, right, Dylan? I mean, it's just the court's going to have to look at that, and in Andrew Brown, they did.
Right. So let's break this down. This balancing test, you're looking at 8 factors. I can tell you right now, if there is an ongoing criminal investigation, that is going to skew highly towards not releasing something. Once an investigation has concluded and we're in a phase of a case where either charges have been filed or they have been chosen not to be filed, then it's more likely than not that there's a higher likelihood, I guess is a better way to say it, that a video could be released. Because here's why. If an ongoing investigation is occurring and you've released evidence that is a part of that ongoing investigation, it could skew parts of the investigation that is currently ongoing. And our goal in our criminal justice system is to seek the truth, is to try to find it as best we can given our current system. And if you're skewing that in certain ways, I can just tell you that my defense attorney brain starts rolling that, well, this investigation was skewed from the beginning. It's kind of like, you know what it reminds me of, Harold? It reminds me of when we see DWI stops and the officer does the portable breath test before they do any field sobriety tests. They might get a positive on the alcohol, and then they do all the field sobriety tests, and then we get to cross-examine and say, well, you were looking for it at that point.
Right.
You were skewed.
That's just why a lot of officers don't. They do it at the end because they're trying to show the perception of impropriety that they are partial, that they're impartial, and that they're looking at every piece of evidence fairly. Particularly in Andrew Brown, the family of Andrew Brown petitioned the court, as we just talked about, to release the video, and some of their representatives to release this video. And it went to a Superior Court judge, and the Superior Court judge did not allow the release of the video to the public. He did allow the family to view the video in confidence, as I said at the beginning, but he weighed those different 8 factors and decided not to release the video. I think part of that, as you said, is because there is an ongoing investigation, and because when Pasquotank County is a small county, and when you're talking about a potential jury pool, I think one of the factors, I think it was number 6 or so, was about the administration of justice and potentially tainting a jury pool. If a jury is watching this and everybody's, this is a national story for a pretty small city, and so you would presume that most people in that city are going to see this video. You're not going to have much of a jury pool to pull from that can be impartial if everybody's kind of made up their minds, seen the video, seen the evidence, made a determination. When you go in a trial, it's supposed to be that you're just looking at the evidence presented at trial, and not anything extraneous, because you don't know what's going to be admitted. So that's kind of why that happened in that case. But again, North Carolina is unique in not allowing it a public record. And I know before the show, Dylan, we talked about whether or not that's a good thing.
Yeah, and it really is up for debate. I can see it both ways, frankly. I think there are a lot of justifications for transparency in government. I know how frustrating it is from our perspective when we're in cases and we're not entitled to certain pieces of discovery, that, you go to somebody and you feel like, well, this could just really help someone figure this case out.
Right.
Either us or you, we're going to figure this case out. We just need the discovery in the case. And so that kind of transparency does help. There's some efficiency there. You can look at what happened in Minnesota. You can look at what happened in Ohio, and people see that, and it did serve to diffuse a bomb. It helped. And so I think people do want some of that transparency, because there is an overall distrust in the government right now.
Absolutely.
I think that pervades through a lot of different socioeconomic levels, political beliefs, what have you. There's people on all sides that, for any number of reasons, do not trust the government. Now, that's a I think that's something that sort of pervades throughout our history here in the United States, is how we kicked off our country. You know,
Right.
we didn't trust the British monarchy, so we said, shoot, we'll do our own.
Right.
But I don't think that that philosophy necessarily goes away. And healthy skepticism isn't bad, but at this current level that we have and the amount of distrust that we have, I think it does serve to help more than hurt. But there is an opposite to that.
No, there is. I mean, we have to look at, as I said, we look at both sides of this, and North Carolina is a little more strict around these rules of releasing these videos. But part of it too is if it is public record, then it's public record. And so you think about all these police encounters that are not, these salacious shootings and stuff like that, where it's a mental health call for a family member, and any police interaction. Body camera footage is supposed to be recorded. So if that's public record, what if it's a mental health call with your son or daughter or your husband, and that's not something you necessarily want to be public record. So then how does that play into this and that kind of footage that may be private,
right? I mean,
for somebody
that could just really affect people's lives. From the mundane level of just being embarrassed,
right?
All the way up to the most serious level of really, affecting your ability to work for a living, and, whether or not, the quality of life for your family and all that stuff. That all plays into it and can have a huge impact by all this stuff being released, potentially.
And one of the factors here is release may harm the reputation or jeopardize the safety. So there's the court is taking that into account, at least in our current system of looking at somebody's reputation. Yeah. So it is, definitely interesting.
If you're just joining us here on WTOB, I'm Dylan Greenwood along with Harold Eustache, and we've been discussing North Carolina's approach to the release of body cam footage, especially as it relates to the Andrew Brown case out in the eastern part of the state. And North Carolina takes a different approach than a lot of other states, and we've had kind of a back and forth about the pros and cons of transparency in government, what that can provide. But from our perspective, because we are attorneys, we do fall into one of the exceptions for body cam footage, because as Harold mentioned earlier, it's kind of this pseudo public record. And public records here in North Carolina, they belong to the people. This has been carved out as an exception to that, and a judge has to determine whether or not body cam footage from law enforcement officers can be released out to the public. But we get to see body cam footage quite a bit, don't we, Harold?
We see it all the time. I mean, I can't count the number of body cam videos I've seen. I know you can't either. It's part of our job. It's part of what we do. We look at these videos all the time. We dissect them very, very carefully. Look at every aspect of them over and over. So that's part of our job. And the way that we get them is, it depends on the county, to be honest with you. But there's generally some sort of correspondence between us and the district attorney's office. The district attorney's office a lot of times gets the footage from law enforcement as part of a prosecution packet or as part of evidence turnover. There's generally a way that police departments and law enforcement agencies turn over stuff to prosecutors' offices, and then that is disseminated to a defense attorney who's on the case. So if Dylan makes a general appearance on a case and is representing a client, our office will make a correspondence with the DA's office, and those videos will be sent to us. Generally, they can sometimes be electronic or sometimes it's a physical copy. It just depends. And then once we have a copy of that, we can't release it to the public, but we can view it. We can go over it with our client. And it really does make a difference. It's really, really important for us to be able to advocate for any client. If there is video footage out there, we always want to see it.
And it is, as Harold mentioned, it is a county by county thing. North Carolina, because of what happened in the Duke Lacrosse case, has pretty strict laws that apply to prosecutors about open file discovery. However, that applies really to Superior Court, where you have a lot of felonies or appeals of misdemeanors that occur. There isn't necessarily as much of a right to true open file discovery when it comes to district court, where the majority of misdemeanors and DWIs are litigated. However, I just, from personal experience, especially when it comes to a DWI, usually the video makes a difference one way or the other, because then you feel like you're at the stop, when something occurs, and the judge, the DA, the defense attorney can really break down what happened there and figure out if it was legitimate. And it's always interesting when you don't get that full discovery, because in the back of your head you're going, well, if this ever did go to Superior Court, we're entitled to have this, we're supposed to have it. I hope y'all have made sure to preserve it,
Right.
Just in case it goes up there. But
and that can become a thing. I just thinking back to when I was in the DA's office, a whole very long motion that I argued about a video that got deleted, and whether that was a Brady violation for our office, the DA's office, or not. And that's a very important issue, preserving that discovery. Is it exculpatory? Is it not? And that's probably something for a whole nother show one day. But Dylan, how are these videos used in court? How do you see them used?
Well, a lot of times they are used in conjunction with some sort of testimony about what occurred during an interaction with a police officer. And they have to come out through the testimony of the police officer, typically. I mean, the overall vast majority of the time, because the police officer, for their body cam, is the quote-unquote custodian of the footage. And so they're the people who can authenticate for the court that what was recorded was actually recorded that day, and they haven't modified it in any way. That way the court knows it's reliable and can admit it in testimony. Now, you can speak to this from being a prosecutor and a defense attorney, but sometimes from a strategy perspective, you want that video to come in. Sometimes you don't, and that can go for both sides.
Right.
And that's always interesting to kind of parse through, because sometimes you only want the testimony to come in. Sometimes it's not so much about the person testifying. You don't necessarily want them to testify. You just rather them show the video about what happened.
Right.
What plays into that decision?
No, that's I can think of many times when I was in the DA's office and I'd be getting ready for a trial, I'd see a video and think, oh, this doesn't really help, and think, well, I'd just rather just have the testimony of the officers, and I wouldn't put that up as evidence. I mean, when you're building a case, you have the ability to kind of offer whatever evidence you see fit, and if the video is not part of that, then it just isn't part of that. Now, a lot of times, of course, in those cases, the vast majority of the time, the defense attorney would cross-examine that officer and get the video in that way.
But not all the time.
But not all the time. And I can think of examples when that didn't happen, and it was certainly to that defense attorney's maybe detriment. But so there's a lot of strategy on back and forth on how these videos are used at trial. It is interesting because sometimes even the videos are really long. And, if a video is, a 2-hour interaction in completeness, well, there are times when, people want to show snippets of videos, and that can also get sort of tricky when you're showing not a complete video, but just a part of a video.
Because it's like taking things out of context.
Right.
And that can go any number of ways. And I mean, I'm sure our audience is well versed with what happens when statements or anything they're taken out of context. A lot of, it can be made to look a certain way. Mm-hmm. You may get to a point where, for the first part of the video, maybe you see an officer that may not be doing exactly everything that they're supposed to be doing. But then the latter half of the video is your client going off on the police officer, being completely disrespectful, or maybe even being assaultive, and you go, oh, you just want to hang your head and be like, well, this isn't great in that part, and I don't want that part to come out. That doesn't make my client look good. And so that's that's something you do think about, and just what the video can show or what it doesn't show. And because the court's looking at everything,
yeah,
they're trying, they're not there, so they're trying to use the evidence to make a decision to adjudicate someone guilty beyond a reasonable doubt.
And I've seen these videos be so important to cases. I've seen them completely exonerate someone or vice versa. So these videos are really, really important. And in North Carolina, we have, like you said, a different way of releasing these videos and looking at them. We hope that that our audience has a better understanding of how how these videos can be released in North Carolina, how they're used at trial, and what exactly they're for. So.
Yep. And so thanks for joining us here this Sunday on WTOB, and don't forget to join us next Sunday. But before we go, we're going to leave you with the Greenwood Law Bill of Rights, and that's first and foremost, I will not represent myself in a court of law. Second, I will not do law enforcement's job for them. 3, I will not make statements when stopped by law enforcement. After all, they're going to get recorded. Mm-hmm. And 4, I will not consent to searches when stopped by law enforcement. 5, I will not be my own star witness for the prosecution. Again, something that can be recorded. It's not a crime to know your rights, to assert those rights. This is For the Record with Greenwood Law, signing off.